Good morning, Your Honors. I'm Robert Massey of the Pulaski-Giles County Bar, and this court has been kind enough to allow Rob Laxon, a recent graduate of the Nashville School of Law who's taken the bar exam, to practice under, in this case with my client's consent, under what us antique lawyers call the limited practice rules. I'll turn the floor over to Mr. Laxon.
All right. Thank you, Mr. Massey, and we're pleased to welcome the recent student and future lawyer. Glad to have you with us.
Thank you. Good morning, Your Honors. Again, I'm Rob Laxon. I would like to reserve 5 minutes for rebuttal.
5 minutes. Very good.
I will spare the court this morning the factual summary. I'll leave that to the briefs other than what I include in oral argument. I do think it would be helpful to review the timeline fairly quickly. This child was born on April 28th of 2017. There was no litigation until September 17th of 2020, at which time Miss M, as I will call her, the mother, filed a name change petition. On December 8th of 2020, Mr. G, the father, responded to that with a petition to establish paternity and a parenting plan. And on April 15th of 2021, Mr. Massey, on behalf of Miss M, filed the answer and the termination of parental rights. At the time of trial, the minor child was 4.5 years old. Our first issue that we would raise as it relates to the trial court order relates to TCA 36-1-113-G14. That is the ability and willingness to personally assume custody of the child or financial responsibility statute, the ground for termination. The trial court applied the 4-month time frame to that statute. There is no 4-month time frame in that statute, nor is there a 4-month time frame applied in any of the case law, both out of the Court of Appeals and the Tennessee Supreme Court, that I could find. Willingness in that statute has been defined under the case law as overcoming obstacles. It's our position, and it's undisputed at trial, that during the 4-month time period and the month before, so from October 20th to April of 21, there was no support paid. And there was evidence, the evidence suggested at trial, and the trial court agreed that the father never paid support himself, that there was support paid on his behalf, but it wasn't by him and it was never reimbursed. The only obstacle that the father in this case had to overcome in order to pay support was simply mail a check. The mother had asked that the check be mailed to an address, and that was
Does that go
done.
to the willingness and ability, or does that go to failure to support?
I think it goes to both, Your Honor. But if we're looking outside of the 4-month time frame, I think it certainly goes to willingness and his lack of willingness to support.
Counsel, I'm struggling a little bit with this order in terms of the termination finding aspect versus the best interest aspect. And one of the things at play here that is there's a determination by the trial court here that Mr. Garrett, that Ms. McCrae orchestrated the 4-month statutory period for purposes of alleging abandonment, and that plays into the analysis of all 3 termination considerations.
Yes,
is the only fact in the record related to orchestration, let me refer to it as the slow walking of the response.
Yes, sir.
Is there any other fact? So if we're digging through the record, are we going to find anything about phone calls that weren't returned, or checks that were turned away, or not responding to text messages? No,
Your Honor, and you actually walk me into the second part of that willingness. Mr. Garrett was allowed every visit he requested. That's in the record with 2 exceptions. And the first one was at the beginning of the COVID pandemic. Mr. Garrett came home from college. Ms. McCrae asked him to wait 2 weeks because he'd been traveling. And she was legitimately in fear of the pandemic. She had quit her job because of the pandemic and the possible exposure. And then the second time was after the filing of the termination petition that she denied him visitation because the child had strep and just didn't feel like getting out. So there are 2 instances in the record of her denying his visitation. And one is because of COVID and one is because of the child being sick. that's after the 4-month period.
Does the record reflect whether the requests for visitation, did they come directly from father or did they come from with grandparent?
I believe they came directly from father. Yes, Your Honor. So it's our position that you cannot ignore the near total lack of effort by Mr. Garrett prior to the filing of the petition to establish paternity as relates to that ability and willingness statute and the ground. As relates to the failure to support that is grounded in TCA 36-1, 113G1, the affirmative defense of lack of willfulness has to be pled, and it was not pled in this case, and therefore, under the rules of civil procedure, should be waived. Willfulness in the case law has been defined as aware of the duty to support, having the capacity to provide support with no attempt made and no justifiable excuse. TCA 36-1, 102-1H raises the presumption that every parent over the age of 18 knows of the obligation to support. So as to the first prong of willfulness, Mr. Garrett is presumed to be aware of his duty to support. He testified at trial he was working during the 4-month period and therefore had the capacity to provide support. It was undisputed that he made no attempt during the 4-month time frame, and it's certainly our position he has no justifiable excuse. Like the mother in Re John A., which is an opinion written by you, Judge Davis, and joined in by you, Judge Clement, the mother in that case knew of her child's guardian's address and did not send support for fear that the guardian would cash the checks and keep them herself. In this case, Mr. Garrett knew of the child's address or knew where he was supposed to send support. He could have provided some amount of support, albeit it might have been small, but instead he provided none. And this court in Re John A. found that the ground of failure to support existed, and we believe that this case is factually similar to that one. The idea behind Mr. Garrett's proposed public policy here is a dangerous one. Filing a petition doesn't cause a child's basic needs to cease and shouldn't cause a parent's obligation to provide support to be postponed. As to the third and final issue we raised in our brief, which is the failure to visit abandonment ground, as has already been mentioned, the trial court based its whole ruling on the idea that Ms. McCrae orchestrated his failure to visit and failure to support. But the biggest thing maybe that I want to highlight today, and the biggest thing that I think the trial court overlooked, was there was a visit during the 4-month time frame. There was a December 20.
I'm sorry, there was a what?
There was a visit during the 4-month time frame. It was a Christmas dinner, so to speak, as we refer to it in our brief, that was allowed, for lack of a better term, by Ms. McCrae. Mr. Garrett requested it. It is the one visit that he requested during that 4-month time frame, and Ms. McCrae allowed it. So I'm not sure how the trial court could have found that she orchestrated it, other than the fact that the trial court had to overlook that one fact, that he requested one visit and he received one visit. The law in Tennessee is clear that it does not support a parent choosing to fail to support or visit a child. Mr. Garrett has chosen to do just that for most of Bella's life, and his choice should not be supported by the law of this great state. Lastly, as the appellee raises issue with regards to the child's best interest ruling by the trial court, I would just highlight that we believe the trial court was correct in doing so, because she knew at the time of trial that she was going to retire, and she is in fact now retired as of August 31st of 2022.
Counsel, a question about trying to take apart here the psychological welfare, substantial harm to psychological welfare. The trial court judge reading that 4-month time period into all 3 termination factors. Can we pull apart that from, and the trial judge saying no substantial harm based upon 4-month orchestration here, can we really pull that apart as an appellate court, or is this something that needs to be remanded to the trial court for determination of whether there is a substantial psychological harm?
I think if you look at the trial court's ruling as relates to the child's best interest. There are enough facts found in that analysis to find that there's a substantial risk of harm to the child under the ability and willingness statute. That would be the appellant's argument. Thank you.
All right, thank you. We'll hear from you on rebuttal. Mr. Davis?
Yes, good morning, Judge.
Good morning.
Jason Davis of the Marshall County Bar. Good to be here this morning on your first day here in oral argument, and Judge Davis, good having you here as well. One thing I will say briefly is there will be no branches mentioned in this case, so I know the court will be happy about that. But as it relates to this very serious matter of termination, as we all know, termination cases are about the most serious thing that we can do in the realm of family law. The lawyers in here are what we would call rural lawyers, practice in the small counties, and while I tell people all the time, Google may not call us to do a lot of trademark work for them. We deal with divorces and custody battles and ultimate terminations throughout our practice. And this case was no different. As the record reflects, the mother in this case simply wanted a name change of the child. It reflects in the record that when asked about the name change by the father, she indicated this had nothing to do with his visitation. She was just, I think, grown frustrated. And I can understand her reason why, that she felt she was pulling the father to be involved and he was not. And ultimately, I think this was kind of the straw that broke the camel's back, or hopefully an awakening for father to go, well, if you're not going to act like one, I'm going to take the name away. As a result, in most cases, and I do want to step back and point out, it's in the record, Mr. Caleb Monroe Garrett, my client, was 16 years old at the time that this child was born. The mother was 18. So for at least 2 of those years, he was under the age of 18, and we'll talk about that more in a moment. But for the fact of he's doing all that he could. He has gone off to university, and we have to have parent involvement. You're going to hear about parent involvement. You've read about parent involvement. But, of course, I have no reason I'll share with the court that the parents are the one that originally had contacted my office, as my client was in the state of Indiana attending university. He'd gone up there to play football, was trying to do the best he could to benefit himself and his education so he could better take care of his child. They said, our son needs representation. That's how I was ultimately engaged in the case and was meeting with him from that point on via Zoom and everything else that we needed to prepare for the case. Well, ultimately, it came to the conclusion, and again, it's throughout the record undisputed, that these parties had tried to work together for many years, as many of our clients do that either can't afford to get into litigation, can't afford to get into courts, or ultimately believe that they can come up with a parenting plan themselves without the court involvement. A lot of younger folks and a lot of people in general are scared of the court system. They have preconceived notions of the court system. They don't understand a lot of it, so they say, we'll just work it out ourselves. Ultimately,
Mr. Davis, you say the parents tried to work these things out, but my review of the record indicates that your client's parents were the ones that were involved and that the father was not trying to work anything out. He was just living his own life. How do you respond to that?
Respectfully, I think Your Honor's correct. I think until a fire got lit under him, that the name change was going to take place. He is, as the court had indicated, he appeared to be very selfish. I think there were some statements in the record that he had to do what was best for him. I think ultimately some of that might have come out a little bit misconstrued in the sense of, I tell people all the time, if you're on an airplane, they tell you put your mask on first because you can't take care of yourself. You can't take care of someone else. I think being short-sighted, it came off that he just wanted to leave everybody and go get an education. Respectfully, I think diving into it more, the only way he could have afforded to get educated was to playing football, and he was trying to get an education to better himself, to give a better life for his daughter. Could he have done that differently? I think he could have. I have 4 children myself. I would have taken the same approach, but it's how we ended up where we ended up, and I think, Your Honor, to answer your question, you're correct. Most of the efforts up until the filing of the petition for the name change, I think we're at the either encouragement of or on the part of the parents of my client.
Counsel, I want to talk about after the filing.
Yes.
So we have this finding from the trial court judge, orchestration, 4-month time period.
Correct.
Is there, same question asked to opposing counsel, is there anything in the record with regard to orchestration that is beyond the sort of slow walking of the response to the father's petition? And are there he was making phone calls, he was sending text messages, he was stopping by the house. Is there anything else that he was doing, that the record supports he was doing after he filed the petition, where there was resistance to his engagement?
No, but I think I can answer your question. I think there are some things that apply, but not on behalf of the father, that lead to orchestration, but actions taken by the mother. So we believe that the filing was made by the father to establish a parenting plan at that point. That was made, I've got my notes here, I think on December the 8th. I've had cases with counsel before. As it's indicated in the record, we received a notice of appearance within the 30-day timeline. As all attorneys do, you reach out. Good to be working with you. I'll get you an answer soon. And I didn't have the squeaky wheel in this case. I didn't have the client, due to his being out of state, that was sitting there going, I need an emergency parenting plan. I need to get in so I can see my child this weekend. That wasn't going to be possible. I wanted to allow counsel time to file his response, as we traditionally do. But
counsel, in addition to not pushing the legal matter, he's also, my understanding, and correct me if I'm wrong, he's also not sending text messages. He's also not making phone calls. The only contact, and I could be wrong, and set me right if I'm wrong here, seems to be the Christmas dinner. And other than that, he doesn't seem to be trying to, he's filed the legal petition. We talk about what the legal weight of that is. But beyond the petition itself, he doesn't seem to be taking actions to try to make payments. He doesn't seem to be trying to make actions to take actions to see the child. Is there anything else in the record that supports that, he got that fire lit under him and now he's figured it out and now he's out there trying to be a dad to this child?
Well, I think there's two things. One and foremost, I think he was listening to the advice of his counsel, that there has now been a petition filed. We are allowing them time to respond. Any communication that he's going to have could be ultimately used in a case against him. He knew that he couldn't physically visit with the child at that point. His parents had no ultimate right to visit at that point. I had also been asked, getting into the support question at that time, as there had been some payments being made up until September, when mother did ask that the payments be mailed. The record shows there were 2 payments in October that they had said, well, we've always operated outside the court system and you've always picked up payments. We feel more comfortable if you pick up the payments. We have them here for you. So there is an argument that could be made. Did father not make the payments, or was mother at this point, knowing that she was going into litigation, because there had been things that she had talked to counsel, refusing to pick them up to create her
case? Make a factual finding on that point, that he found unconvincing the rationale that was offered for why the checks weren't being mailed?
The judge did say that that was basically not a rational response to mother asking that the payments be mailed. And if I could step back, I think this is important to your orchestration, because I think the court spent a lot of time in the order about the orchestrated matter. At the time that we filed our petition to establish, all we believed that was going to happen at that point, we would ultimately get a response. We would most likely set the case for a mediation. If it didn't settle, we would go to trial. We would get a parenting plan. And again, the urgency that lacks there is, again, in the record, my client at this point is out of state and university. He's going to be going to the military. He wanted to establish his rights. He did not try to remove custody. It's riddled throughout the file. There was never any occasion that he was asking for a change of custody. He simply wanted to get something more established at that point, albeit it was going to be very small. But we never anticipated standing before the court on a termination proceeding, and we never thought that we would be here, because at the time that we had filed, mother was not even married. There wouldn't have been an ability at that point to ask for a step-parent adoption, because there was no step-parent. The record reflects that when we filed this in December, a notice of appearance was filed December 29th, no answer filed to April 15th. Mother wasn't even married until March the 27th. The reason given at the trial court level is they wanted to, I think, honor an anniversary maybe of a great grandfather. There was some family day that was important to them for March 27th, which I can appreciate. But when you take a step back and look that they had notice, they had well-learned counsel, they had already filed the notice of appearance, and then there was this lapse in time where we're waiting on a response. We believe essentially they took that opportunity. It was testified to in court. They had met with their lawyer at that point. Probably advised, we assumed at the trial court level, that, well, you need to go get married. They got married on the 27th, and then on April 15th, a petition for termination of step-parent adoption was filed. Mr. Garrett never anticipated to be defending a termination case based, one, on the statements made by mother when she had indicated to him, this is just about a name change, not your rights, and two, there was no stepfather to speak of at the time that we filed our petition to legitimate. We believe this was something that was, what are my options? Well, if you play it this way, this is how it could happen. And that's ultimately the path they chose.
Counsel, this isn't a case where you have a resistant parent, right? And you don't have a parent in this case that's that's run away and is not responding to text and not responding to phone calls and not responding and keeping the other parent at bay. You have a parent who's not really doing a lot to see or support that child. When you have a parent who's actually welcoming and then trying to engage. Now that flips at some point here, I recognize, but that makes it tough for me in terms of thinking about this time period. If the only action he took is filing the petition. And
I think that's where it flipped, though, Judge. I think that there was a lot of encouragement, but I think that is where ultimately it did flip, which is upon the filing of the petition, where I think that did upset the mother. Now, she did allow for a token visit that time, but I think probably, again, I think reasonable in doing this a lot is, well, if this thing does end up in trial, you don't want to be the parent that looks like you're pushing the other one away. So if dad's home for a Christmas break and wants to visit, I think you should allow it.
Counsel, can we talk about your client's failure to manifest a willingness and ability to assume physical and legal custody of this child, which is not reliant on this 4-month orchestrated period? And that's why I'm troubled with the trial court's order, because the trial court basically lists the ways in which your client failed to manifest an ability and willingness and then says, oh, but the 4-month orchestrated period. That's just wrong, is it not?
Well, of course, I can't sit here and say that it's wrong when I agree with the order, but I will admit to the court I was confused in reading it. If we've ever been there where we've read through multiple pages, then you flip to the last page and there's an ending you didn't expect. I think the court was very hard on my client. Some of that obviously brought on by himself, but ultimately I think the court says that what we are having to look at in a termination case is that 4-month period, and I don't believe that there was a finding by the trial court that this willingness and ability, I don't know if it's a chicken and egg. Was it that he really wasn't wanting to do it? Was it that life circumstances based on having a child at 16 and trying to get an education? I think even in part of the finding it said, well, while he's in the military, he's not going to be around, but there are going to be benefits that can be provided in insurance and things for the other child.
And all of the things he was doing, I mean, I guess if we view it in the light that you've suggested, I'm not sure the record bears it out that he did these things ultimately for the benefit of his child. That's all well and good, but no phone calls, no FaceTimes, no nothing.
I wouldn't say that there was none. I think there was very little. So I think if you're going to err on which way the scale is going to tip, it's going to lean more towards none than it is more. But again, I think that is also due to the fact of the relationship between the parties. And also, I think there's just some fundamental issues that were in dispute as far as it was put in the records that she didn't know where he was. And he said, of course she knew what university I was attending. These were young people that had a child trying to figure out. I think there was a lot of drama and probably some gamesmanship on both sides that ultimately ended us here. But I do think what kind of forced both of them to grow up very quickly was ultimately the name change that lit the fire. He did retain counsel. He did want to file. He was my client, not his mother and his father. This is not a grandparents' rights case. It was him. And we jumped into it believing honestly that at that point, and my advice was to him, was I never even put on the radar we'd be standing before the Court of Appeals on a termination case because mother wasn't married at the time that it was filed. And I just thought that the timing of it was suspect. I think the trial court picked up on that the timing of it was suspect. And it was also argued at the trial court that basically terminating this child's right is not going to make this child's life look any different. But on the other token, based on father's commitment, he's in Korea, as I'm here arguing this case today, not terminating his rights and allowing the child to benefit from being able to be on father's insurance and get other benefits from father, and the ability for the mother to get financial child support from a father ordered by the court are all things that will benefit this child with her day-to-day life not looking very different. She's still in the home. She's still going to have a relationship with the stepfather. She's still going to be in her mother's care. We're just basically saying if there's more people that can love a child, that's great. Then fundamentally disconnecting half of this child's family from them, and we can all hope and dream that mother would encourage a relationship with these grandparents and the people that are close and the father at some point if the child wanted to. But we're putting a lot of faith in someone, as we all know in the justice system, that if we can't order them to do something, we can only hope. And I don't think this is a case where we wanted to hope. So our position was that the way it came about was to use maybe an insurance term, there's a lot of good faith we felt that lacked in this case about the way it got handled and the way it got filed. We would respectfully just ask that the trial court be upheld, that the termination petition be dismissed. We do not think that it was properly orchestrated, to use the word of the day, in this proceeding, and that would be our argument before the court.
Thank you, Mr. Davis.
Thank you.
We'll hear a rebuttal.
One of the things that I want to go back and highlight as relates to the time frame, because a big deal has been made about the 4 months and maybe slow dragging our answer, is September 17th of 2020, the petition to change the name was filed by Ms. McCrae. Almost 3 months later, on December 8th of 2020, did she get a response. So they waited 3 months, we waited 4 months, maybe we're both slow walking it, but there seems to be a little bit of slow walking on both of us, I suppose. As relates to Mr. Garrett going off to college to play football, the reasoning that was given for that was that he had to, that was his only way he could afford to go to college. There was proof at trial at that time. There were 2 years of junior college tuition free in Tennessee. He could have enrolled in Columbia State, which was 30 minutes from his child, and he could have lived at home and driven back and forth to college, and at least got a 2-year degree, if not further.
Counsel, the weight that the trial court is putting on the filing of the petition in this case, in reviewing that on appeal, are we looking at a determination of something that we should view as a question of law, or is it a question of fact in terms of abandonment with regard to the act of filing the petition and whether an abandonment has occurred or not? And trial judge seemed to put enormous weight on the fact this petition was filed. Is that a factual determination with regard to abandonment? Is that a legal determination with regard to abandonment? How do we view that?
You're asking whether or not the ground of abandonment exists. Is that a question?
The weight that's placed on the filing of the petition itself.
I think legally the only weight that the petition bears is it sets the 4-month period for the failure to visit and the failure to support. I'm not sure how else to answer the question as to what weight the filing of the petition carries.
And your position is there is no 4-month period for the third ground of willingness to assume responsibility?
Correct. Yes, sir. There's not statutorily, and there's not in the case law. It's to borrow a phrase from criminal law, it's essentially a totality of the circumstances.
Counselor, your review of the record and order is the only barrier to the finding of psychological harm to the child, substantial psychological harm to the child, the 4-month orchestration. There's sort of the judge is saying it would be psychological harm if not for.
She certainly alludes to that. I don't know that I can go as far as saying that's what she finds, because that's certainly not expressly in there. But she does say that the father is essentially a stranger to this child. And there's case law that says that placing a child in the custody of a stranger will cause psychological harm. That is the problem with allowing Mr. Garrett to continue his paternal rights, is either we're going to keep this 365-0 plan forever, at which point, what's the point, or we're going to place a child with a stranger, which is essentially at the last visitation he had with the child, she didn't even recognize him. I would point out back to going off to college and playing football, not only could he have gone somewhere close in state 2 years for free, he dropped out of not only the college he went to, but I believe the record also shows he dropped out of a second college. And after that, stayed in Indiana, was not going to school, and was working odd jobs, Cracker Barrel and some other places. He didn't move back to achieve custody with his child. And as Mr. Davis alluded to, he wasn't a squeaky wheel client. There was the petition which is our position, that that's just a hollow petition because nothing was really done before it and nothing was done after it. As your honors have alluded to, there was no calls, there was no messages, there was certainly no support paid. And I think if you look at the statute as relates to support and the obligation that a parent has to support their child, there's zero excuse for that, regardless of whether you're seeing the child or not, or where you're living. Mr. Davis also admitted that the Christmas visitation was in fact token. And if we're going to enter a 0365 plan, it should Mr. Garrett win this appeal today, there's still no other parent to love and care for the child. Thank you.
All right. Thank you both for your arguments. We'll take this matter under advisement. That concludes the morning docket. Madam Clerk.